The Remedies question from February of 2001 is a challenging, complicated question, and it also gives us good insights into how to organize and think about remedies. Have a look at the call of the question with me. What remedies are available to Pete against Diane, and on what theories of liability are they based? Discuss. Well, you couldn't get a more straightforward remedies call of the question than this. The only thing you really need to know up front is that we should lead with the theories of liability and follow up with remedies. Just because the call of the question put remedies first doesn't mean you have to. And, in fact, analytically, it's a lot better to put the theories of liability first. And that's why those of us who go to court do so in our pleadings. We always put the theory of liability up front, and then the prayer for relief follows. Let's have a look at the fact pattern itself. It's pretty complicated, and there are many different theories of liability. Incidentally, this phrase, theories of liability, and call of the question, it's a hint. It's a hint that more than one subject is being tested here, including remedies. So we can expect torts and contracts to be tested, or contracts and property. Here, as it turns out, the principal theories of liability will come from the law of real property and the law of torts. Go to the top of the fact pattern and let's review it together briefly. In paragraph 1, we find out about Diane constructing her office building on property adjacent to Peter's property. So we meet the two parties up front. Diane had a narrow lot. She didn't have much latitude, and it turns out that her building encroaches 10 inches onto Peter's property. It's a big problem, and it will turn out to cause further problems. As she builds her building, she inadvertently destroyed 24 ornamental trees that had been on Peter's land. So we've got two theories of liability up front: encroachment, based really on the law of real property, and conversion, the destruction of the trees. In paragraph 2, we find out more about Peter and about the harm that he has suffered. Peter is a restaurateur. He has maintained a garden for a number of years. The vegetables can't flourish without the filtered sunlight that the trees had provided, but Diane destroyed the trees, and therefore the vegetable garden has suffered. That's caused Peter's costs to rise, damages, and his reputation has been injured, and the long-term effect on Peter's business is incalculable. Why do you think that phrase is in there? Answer: because it is supposed to tickle our fancy, or at least point us towards equitable remedies. If we can't calculate the legal damages, that's one good reason to turn to equitable relief. And as it turns out, it may not be quite a good enough reason in this case, but it sure is compelling. In paragraph 3, we find out a little more about Diane. She's had tenants in her building since it opened. Most of them have long leases, and to remove the wall that encroaches onto Peter's property would be expensive, it would reduce her office space, and it would disrupt the tenants on that side of the building. They might be able to claim a constructive or real eviction. In paragraph 4, we find out about a parking lot. Diane's tenants have been parking there for some time. She paved the lot thinking it was on her land, when, in fact, the lot is almost entirely on Peter's land. Diane's been charging $50 a month per space. Peter's never voiced an objection to this practice because until a town survey was completed, he didn't even know the lot was on his land. And then we receive the call of the question again: what remedies are available to Peter, and on what theory or theories of liability might they be based? Okay, let's look at the outline of issues that I've presented, and I think you'll see once again how important it is to organize our thoughts carefully before we begin to write. I suggest a series of theories of liability, as you can see on the outline. We've got the encroachment of the building, which, by the way, also could be considered a continuing trespass. We see that the trees have been destroyed. That's a conversion. It also could be considered a trespass causing severance, and we might also consider it to be waste. Now here's a detail that's worth thinking about. They asked us about theories of liability. That means they're testing our law knowledge. We're not supposed to just bark out a lot of boilerplate definitions, but we sure do need to have the theories of liability available right on the tip of our tongue. So I would suggest that it's a lot more important to make sure you have a comprehensive list of theories in your head rather than rote definitions for all of the theories. Obviously, you need to understand how the theories work, and you need to know what they're called. Next, we turn to Diane's defenses. It doesn't look like she has any, other than a lack of specific intent to harm this plaintiff. The bottom line, I conclude that Diane is liable, and the only issue that remains is to what extent will Peter be able to obtain remedies to compensate him for his harms. Notice my organizational structure for remedies. They've asked us about remedies. It's a straight remedies question, and so I have a separate section for each of the three major categories of remedies: damages, restitution, and injunctive relief. You'll see that I consider damages with regard to the encroachment, the trees, and I consider punitive damages, because even though Diane did not have the specific intent to harm this plaintiff, she did deliberately engage in conduct that hurt him, and as a result, he may be entitled to punitive damages. Next, we consider restitution. Here we can find a home for the details involving that parking lot and the $50 per month per space. I note in the outline that Diane will have a right to recoup her investment, improving the property, to put the parking lot on it. Then we consider injunctive relief in torts. Here I just go through the elements. We'll wait to review the answer to consider them in greater depth. Then I arrive at a conclusion. Now, what I think makes this problem hard is the fact that it's hard to balance the hardships. It looks as if Diane has done wrong, but she doesn't seem to be particularly bad. She isn't like a lot of the intentional tort defendants that we see, who really are pretty wicked. Here we've got someone who appears to have done wrong, but in about as innocent a fashion as possible. Peter, on the other hand, is totally blameless, and he has suffered some very significant harm. So let's have a look at my answer and see how one person might choose to address those grievances. I start off at the very beginning of my analysis with a fairly long paragraph setting up the situation. I explain who Peter is, and I explain Diane's situation too. I suggest up front that Peter has suffered several specific types of harm, which I list, and then I indicate that Peter is going to pursue theories of liability for each of his harms and will seek compensatory and punitive damages as well as restitution and equitable relief. I think this paragraph helps put the reader on notice that the writer has spotted the issues and will analyze them appropriately. I don't think this paragraph is essential, but I do think it's helpful, and that leading with the facts almost always is a good practice, so long as you don't merely copy the fact pattern into your answer. So let's look at the encroachment issue. I call it a continuing trespass 2 from 1998 through the year 2000. I explain both Peter's discovery and Diane's ignorance. Ultimately, the conduct of the defendant is intentional and it's wrongful, and it will entitle Peter to remedies. Next, we consider the destruction of the ornamental trees. Here I spend more time on conversion than I do on trespass causing severance, because I think it really is a conversion question. But certainly trespass causing severance is relevant, and waste also would be considered relevant, because even if Diane hasn't deliberately converted these trees, her conduct has resulted in the waste that Peter has suffered. Again, is it essential to talk about all of these theories of liability? Well, I guess it depends on how you define essential. You could have gotten away without including the waste issue and still pass this fact pattern. But you really do need conversion and trespass causing severance. And in my judgment, if you're sharp on remedies, you'll come up with all three of them. And if you miss them, this is a fact pattern that you may find extremely instructive. Next, we consider the encroachment, parking lot, which in my judgment also constitutes a continuing trespass. And it seems to me that there is a restitutionary remedy available as a result of this theory of liability. We'll get to that in Part 2. I spent 3 paragraphs considering defenses that Diane might interpose, and they aren't very strong. All she can really say is, I acted out of ignorance, not out of spite, and that isn't good enough for her to be able to escape liability. Furthermore, I do touch on the idea that there might be some sort of adverse possession issue. I'm very brief about that, and certainly Diane has not occupied this property long enough for that to really be a possibility. The bottom line is Diane is liable, and Peter is going to be entitled to seek all of the different types of remedies that we've referred to previously. So when we get to Part 2 of the answer, this is, in my judgment, the more elaborate section. This really is a remedies question. This isn't a question so much about the theories of liability, although Lord knows we've got to come up with a pretty big laundry list of theories of liability, don't we? But let's now look at the remedies section of this remedies question. You'll see that I'm organizing the remedies analysis around the different harms the plaintiff has suffered. I start off with the encroachment of the building. Certainly, the plaintiff will be entitled to restitution for that encroachment and also damages as well. With regard to the trees, the plaintiff certainly is entitled to compensatory damages, and with regard to the trees, that's for the trees, and with regard to the increased costs, the damaged reputation, and the incalculable lost business. Here I've got separate things to say about each of them, but it seems to me that to the extent that this plaintiff can quantify his harms, Diane certainly is going to be liable for them. Next, we turn to punitive damages, and it seems to me that punitive damages may be limited on some levels, but it's also true that punitive damages to some extent may be necessary to make this plaintiff whole, given how incalculable some of his harm really is. I consider restitution for the parking lot. Here you'll see that I find a home for a number of details, and I conclude that Diane is entitled to recoup her investment, but in the end, she's not going to be able to retain the profits. We turn to injunctive relief, and here, this is about as elaborate an injunctive relief analysis in torts as one could be called on to produce. And you'll see that ultimately, I am rather sympathetic to the defendant, which may be no surprise, but it's really the plaintiff who's been wronged here. I indicate up front what the plaintiff is going to seek. He may seek to force the defendant to remove the encroaching part of her building and the parking lot, and he does have a fairly strong claim for equitable relief. Certainly his legal remedies aren't adequate, given both the inherently unique nature of real property and the fact that we are told some of his damages can't really be calculated. The property right of this plaintiff is as unambiguous as could be imagined. Similarly, the courts got in personam jurisdiction over the parties and in rem jurisdiction over all the real estate, so feasibility doesn't present any problems. But balancing the hardships is a very difficult problem here. Ultimately, given that Diane is entirely in the wrong, the balance probably favors the plaintiff. But I think it's a close call. And when we reach the conclusion, certainly you'll see that I show some empathy for both sides of this dispute. I find it rather difficult to imagine that Diana will be required to remove the encroaching part of her building. It seems to me better for everyone involved to compensate the plaintiff financially, even in the long term, for this encroachment, rather than to require Diane to remove it physically. Now, I can admit to all of you that it's possible to write a very good answer that reaches a significantly different result here. Perhaps I've tried to be a little bit overboard in showing fairness to both parties, when it is Diane who, in fact, is the only wrongdoer. Still, I think you will find that the answer that I present does fall well within the mainstream of what the passing answers look like. And whether or not you entirely agree with my analysis, and there's certainly no reason why you should necessarily, I do think you'll agree that what I've done is a thorough and comprehensive job both of establishing plaintiff's theories of liability and in dealing with his anticipated prayers for relief.